Judgment in the matter of Brown against Ridley and another.
In 2002, Parliament radically reformed the regime governing the ownership of registered land in England and Wales by the Land Registration Act 2002. In particular, it greatly reduced the scope for the acquisition of ownership of registered land by what lawyers call adverse possession, that is, being in possession of the land without the permission of the registered owner. Before 2002, 12 years adverse possession had the effect of barring the title of the registered owner under the Limitation Acts. Under the new regime, no amount of adverse possession bars the title of the registered owner, but 10 years adverse possession gives the person in possession a heavily qualified right in certain circumstances to apply to be registered as the owner, provided that the possession continues until the time of the making of the application. One of those circumstances is where the applicant, I'll call him or her the squatter, is in adverse possession of land adjacent to the boundary with land which the squatter already owns, where the register does not precisely define where that boundary is. But the squatter must show that, quoting from the legislation, for at least 10 years of the period of adverse possession ending on the date of the application, the applicant, or any predecessor in title, reasonably believe that the land to which the application relates belonged to him. End of quote. The quoted words have given rise to two possible interpretations. 1. Must the squatter hold that reasonable belief for 10 years ending on the date of the application? Or 2. Is it enough that the squatter holds that belief for any 10-year period during the period of adverse possession ending on the date of the application? This appeal asks the court to choose between those two interpretations. In the present case, Mr. and Mrs Ridley bought a house and garden called Valley View in Consett, County Durham, in 2004. Their garden appeared to them to include a strip of land which was in fact part of a much larger undeveloped adjacent plot of which Mr. Brown was the registered owner. But the strip looked like part of their garden because a fence and a Leylandii hedge ran around the outside of it. In early 2018, they applied for planning permission to build a new house in their garden, eventually called Moonrakers. During that planning process, they discovered that part of the garden might be part of Mr. Brown's land, but they went ahead, pulled up the hedge and built Moonrakers, partly on Mr. Brown's land. He objected, and in December 2019, the Ridleys applied to be registered as the owners of the disputed strip, on the basis that they had, for over 10 years, been in adverse possession of it. The first-tier tribunal judge found that the Ridleys had indeed been in adverse possession of the disputed strip until they made their application, but that their originally reasonable belief, held from 2004, that they owned it, ceased to be reasonable in February 2018, some 21 months before they made their application for registration. But he said this didn't adversely affect their claim, because he considered that what I've called interpretation 2, that's any 10-year period will do, was the correct one. So he ordered the Ridleys to be registered as the owners of the disputed strip. Mr. Brown appealed. The upper tribunal considered that it was bound by an earlier Court of Appeal decision in 2011, called Zarb and Parry, to the effect that interpretation 1, the 10 years belief must end on the application date, was correct. But the upper tribunal judge, the president of the Lands Chamber, thought that if he'd been free to do so, he would have preferred interpretation 2. So he allowed Mr. Brown's appeal, but granted the Ridleys permission to make a leapfrog appeal direct to this court, bypassing the Court of Appeal. This was because he thought, since the Court of Appeal is also bound by its own previous decisions, they might be obliged just to follow Zarb, regardless of the merits of the argument in favour of interpretation 2. For the same reason, this court permitted the leapfrog appeal to proceed. This court unanimously allows Mr. and Mrs. Ridley's appeal, because we consider, like both the expert tribunal judges, that interpretation 2 is the correct one, and that the Zarb case was, in that respect, wrongly reasoned. In fact, that part of the reasoning in the Zarb case made no difference to its outcome on its particular facts. I give the lead judgment, with which Lord Hamlin, Lord Stevens, Lady Rose and Lady Simler all agree. Our reasoning is, in summary, as follows. 1. The process of statutory interpretation requires the court to ascertain the objective intention of the legislature as manifested by the language which it has chosen to use, interpreted in the context of the legislation as a whole and with due regard to its underlying purposes. 2. The language of the requirement for reasonable belief could lead to either of the rival interpretations, but on close inspection it tends to favour interpretation 2. 3. The overall purpose of the 2002 Act in relation to adverse possession is to reduce, but not to eliminate it, as a means of obtaining ownership of land, and the deleterious effect of adverse possession on the reliability of the register. 4. But the obtaining of ownership by adverse possession is clearly preserved in the context of boundary disputes, because that is where the register is least reliable, since it usually only provides general rather than precise boundaries. 5. The purpose of the requirement for reasonable belief in ownership is designed to make sure that squatters who take and persist in adverse possession, knowing that they are trespassing, do not thereby obtain a right of ownership. That purpose is achieved equally well by either of the rival interpretations. 6. But interpretation 1 suffers the very serious disadvantage that squatters who had held a reasonable belief in their ownership for 10 years or more could only rely upon adverse possession if they applied to be registered on the very day when they were shown something which made that belief no longer reasonable. This would impose such an unrealistic burden on the squatter that the statutory right to apply for ownership based on adverse possession, backed up by reasonable belief in ownership, would be rendered illusory in most typical cases, including the present case. It would also tend to drive neighbours into headlong litigation, even where the relevant boundary was not a matter of dispute between them when the belief ceased to be reasonably held, as in this case. Parliament has by other legislation made clear its intention that civil litigation about this kind of dispute should be a last rather than first resort. 7. This fundamental problem with interpretation 1 could not be cured by applying what is sometimes called the de minimis principle, because the reasonable time needed by a squatter to take advice upon and prepare an application to be registered, once disabused of the necessary reasonable belief in ownership, would be neither short enough nor sufficiently trivial to come anywhere near qualifying as de minimis. 8. Finally, interpretation 2 did not contravene the registered owner's right not to be expropriated, conferred by Article 1, Protocol 1 of the European Convention on Human Rights. It was far less invasive of the rights of the registered owner than was the old adverse possession regime, which the European Court of Human Rights had found to be compliant with the Human Rights Convention in a case called Pi in 2008. For those reasons, this appeal is allowed, and the order that the Ridleys be registered as owners of the disputed strip is restored. The court is now adjourned.